Let's speak to an assistant director at the Ethics and Anti-Corruption Commission. We were hoping to speak to the CEO, Twalib Mbarak, who sadly told us that he has been called into an urgent meeting, and therefore he's asked his assistant director, Phillip Kagucia, to speak to us. Phillip, good morning.
Good morning, Eric.
It's good to speak to you again, Phillip.
Yeah, it's nice to be back. Greetings from my CEO, Major Twalib, and apologies that he couldn't make it today.
It's all right. At least we have you.
Yeah.
And you're a wealth of knowledge. Just briefly, Phillip, just take us through the chronology of how this fraud was perpetrated.
Well, you've seen quite a lot which has been shared out with the media houses, but the long and short of it is that Eldoret Supplies, as a general suppliers company, purported to have procured maize, and this was to sort of fill a shortfall. You know how we normally expect we'll have a certain amount of millions of bags of maize. And they went through some tender process, and Eldoret was awarded a tender to procure a portion of that maize. The only problem with this tender, because Eldoret was supposed to bring in about 40,000 metric tons, is that in the end, they never actually delivered even a single kernel, a single grain of maize. However, they had documents which they presented to demonstrate that they had shipped this maize, they had stored it somewhere in Djibouti, they had somehow delivered it, and that they wanted payment. Now, unfortunately, when this matter was taken before arbitration, the arbitrator actually placed a lot of emphasis on those documents, which now the court has said were forgeries, and on the basis of those forged documents, gave an award for the entire amount which they supplied.
And how much was that?
If you look at the figures there, it is 577 million shillings worth of maize. That's over $500 million.
Yeah.
Right? And now because they had this arbitration award, they could now use it to go and enforce the decision of the arbitrator, and that is where the rain started beating us.
Sorry, just to take you back there, Phillip. So when they were going for arbitration, what was their charge against the NCPB?
That they had not been paid, yet they had delivered.
So they were saying that they have delivered maize and they have not been paid.
Yes.
And the truth of the matter is NCPB stores had no maize.
They had no maize. There's no evidence that they ever delivered a single bag, a single grain, a single kernel of maize. Okay?
Yeah.
All they had were these documents, which now the magistrate's court has established were forgeries.
All right.
Yes. So as I was saying, so the 577 million award is what they were trying to enforce as against NCPB. So they had these orders, and using these orders, they would freeze NCPB accounts.
Yeah.
They would attach NCPB assets.
Right.
I think if you look at the report, you will see stories of seizing warehouses, vehicles, laptops, furniture, because they had to realize their judgment one way or the other.
Right.
Now, it is because of this that NCPB's account, which had 297 million, was frozen, and all that money transferred to the law firm. And you will see the flowchart of how much the money hit the law firm, how it was distributed.
Yep.
And if cumulatively, if you look at the money that was actually taken out of NCPB, that's what gives us the figure of 313 million.
So 313 million, basically, with in their enforcement of what they had gotten as orders to get money from NCPB, they basically froze all these assets, froze accounts, and went into the accounts and took the money because they have the orders.
And mind you, they only managed to get about half, right? Because the original award is
577 million.
So here's what I want you to think about and Kenyans to understand. Had it not been for the intervention of EACC, they were actually going to pursue the entire amount, 577 million.
So what did EACC do? At what point did EACC come in?
So EACC commenced investigations, I think, in 2013. But as you're aware and as you've mentioned, because I listened to you earlier on the show, these investigations are complex, they take time. And one of the aspects which was challenging is the international element.
Yeah.
A significant portion of this evidence has to be sourced from South Africa, because Erad Supplies are claiming that they used a shipper, I think a company called Chelsea. And they say that they paid Chelsea, and Chelsea is the one who shipped, and then it was stored somewhere in Djibouti, and so on and so forth. Now, in order for Kenya to get that kind of evidence from another state, we have to invoke a process called mutual legal assistance.
Yep.
And it's a fairly complicated process. It's quite convoluted, and it goes through very many channels before it is actually accepted on the other end. Because remember, there's some requirements. For instance, I might be shouting about something here in Kenya, but out in South Africa, it's not a criminal offense.
Yeah.
So these are among some of the things you have to demonstrate. Sometimes when you do mutual legal assistance in other countries, like France, you have to do a translation from our official language to French.
Yeah.
So these are some of the things that maybe lengthen the process of investigation. But we got the evidence, and the fact of the matter is Chelsea Freight never transacted with Erad Supplies.
Never knew them.
Never knew them, didn't even deal with maize, as a matter of fact.
But how did they come up with Chelsea then?
And this is the thing. Remember,
Tricks
white collar criminals. Yeah, white collar criminals are not the same like the guys who do breaking and entering. The guy who does breaking and entering, his thinking is rudimentary. Atavuja mlango, and then he'll come and take your stuff from your house.
Yeah.
But these are guys who are well educated, and as you've seen, they are also what we call PEP. Politically exposed person.
Yeah.
They are well connected. So they're educated and they're connected and they know exactly where to push the buttons.
And they're people of means.
They are. And they have access to offices where ordinary Kenyans like you and I would not have access to.
Philip, can I ask you then, as we're looking at the chronology of all of this, at what point did EACC step in to know that, okay, there's something awry going on here? What gave light to then the introduction of EACC?
Well, generally speaking, we receive thousands upon thousands of complaints, right? And what we go through is you go through a process of prioritization. And the ingredient sometimes for prioritization is simply the value of the subject matter. So, for instance, in this case, we were talking about over 500 million Kenyan shillings. So that obviously bring this file right up to the top of the pile.
Okay.
Out of the thousands. The other thing that sometimes is the public interest in the matter.
Yeah.
Remember, we're talking about food security here. And this is one of the president's big four agenda. Okay? So you can imagine how much these guys are affecting what we are trying to achieve as Kenyans.
Yeah.
So again, that would bring this report right up to the top of the pile. And the other thing that sometimes we consider is the profile of the persons involved. So in this case, we have a sitting member of parliament. We have Grace Wakungu, whose relations are now public knowledge.
Yeah.
And we also have the person who may have been the mastermind, the late Jacob Juma.
Yeah.
So if you look at these people, their profile is not the profile of an ordinary Kenyan. So those are the things which probably accelerated this matter and put it as a top priority investigation.
So the case that you took in court, the case that you presented to the DPP, was basically based on the forgery of documents that Chelsea had shipped maize on behalf of Erad.
Yes, because we have a wonderful team of investigators and lawyers who came together, and what they established is that there was nothing that was actually procured on behalf of NCPB by these guys. So the task is to bring this to the attention of the Director of Public Prosecution, and I must say the DPP lawyers did an incredible job. And they went and presented the case to the magistrate. And after, fortunately, I don't know if you took note of this, that this case was actually concluded in less than 2 years. So it's an example of also the judiciary making an effort to resolve corruption cases within a reasonable time. So we presented this evidence before the court, and the court agreed with us, because if you take documents and they're looked at, and the specialists who do this, for example, we have document examiners, and the document examiner looks at this document and says, it's a forgery. And if this forgery is the basis for the award, then that award is not a proper award. And that is why it is easy now for the magistrate to say that you guys are guilty of 1, 2, 3, the uttering of false documents, forgery. And also there's another element. There's a meeting of minds. These people, they thought, they planned, and they intended to defraud the Republic of Kenya. Because remember, this money that is going out from NCPB, this is taxpayer money.
True.
So I think based on the quality of the evidence that was presented to court, it was possible for the magistrate to establish that, no, this transaction was fraudulent, they should not have been given the arbitration award, and on top of that, they should not have gone and done what they did by freezing accounts and freezing assets in order to realize the award.
Now, looking at the kind of fines that they've been given, when it comes to all the way to 700 million shillings plus, what is the magistrate using to give these kind of hefty penalties? Right.
Now, we have a section of the Act which talks about your normal fine for that offense under Section 48, which basically says, and remember, a fine is a punishment. Okay? Ni kiboko mtu anachapa kwa ile makosa amefanya. So, you have 1 million fine and imprisonment, on the other hand, or both. Okay? But that same section has an additional mandatory fine. Okay? And I'd like us to understand this. There is an additional mandatory fine. And why is it a mandatory fine? It is a mandatory fine because, on the one hand, either there was a loss, okay? Because these guys, by their fraud, they caused the NCPB to lose money. And on the other hand, if there was a gain to them individually. Because they caused a loss to NCPB, and on the other hand, they fraudulently gained some money themselves, personally. Now, what the law says is that fine, that mandatory fine, it can be up to 2 times the value of the loss, and up to 2 times the value of the gain.
Giving the magistrate the leeway to place, as long as it's up to 2 times.
And normally the judicial officer will have discretion because the sentence says from here to here, so you have a range, you have a spectrum. Now, if you look at the figure that is quoted, the most frequently one is the 297 million. If the magistrate takes the 297 million and doubles it,
594.
You get 594. Okay, and because there are several counts, you will find that the Honorable Member of Parliament, Waluke, will have his own 594. Grace Wakungu will have her own 594. That is because of the loss they caused to NCPB. Now, then there's this secondary part, which is how much did they gain? And if you look at the chart of how money was being transferred, you'll see that Waluke got 50 million. So it is that 50 million which is now doubled. So that makes 100 M.
100 M.
On the other hand, Grace Wakungu got 40 million. Because it's double the gain, that is also doubled, that's 80 million. And if you add that with all the other losses or gains that were losses suffered by NCPB or gains made by them individually, when they are doubled, that is where this amount comes to 700, well, it's in excess of 700 million per accused person. Yeah, and it's an unprecedented thing, and that's why I think it has sent shockwaves through the country.
It's a huge figure. Also, then, they clarify for us this. It's either, for example, count one, 100,000 shillings fine or 1 year in jail. And then there's count two, the X amount or X number of years in jail. Are these jail terms successive? Are they happening one after the other, or are they happening concurrently?
At the time we were going to bed, which was really late last night, it wasn't clear whether they are concurrent or consecutive.
Yeah, consecutive.
But we will be operating on the understanding that I do not believe it was the magistrate's intention to, because cumulatively we looked at, for example, in Oluka's case, if you look cumulatively at all the fines and all the prisons, the custodial sentences against him, it is in excess of 50 years.
Yeah.
So I am not sure that was actually what was intended by the court. I would, for the time being, without having full understanding, I would assume it is maybe concurrently, and maybe the maximum is the 7 years, which was the highest sentence.
Okay. Phillip, just looking at that now, this jail term would be upon failure to pay these fines, is it not?
Yes, that's correct.
And what kind of time period are they being given to pay? Is it kind of like you pay by the close of business on Friday and you can, scurry on home, or what are we looking at here?
Yeah, so the last order that the Honorable Magistrate made is that those fines should be paid within 14 days. I think if I look at the report which was prepared by my colleagues who are in court, it talks about them paying within 14 days, failing which EACC can commence recovery. Now, what does that mean? That means that if EACC does not see that money within 14 days, we start looking for, within 14 days, should they fail to pay, we start looking for the assets. And there's a process for civil execution, which may involve auctioneers and so on and so forth.
Right.
So you go and find whatever property these people, because it's a judgment of the court and it has to be realized. Much in the same way, they were busy realizing the arbitration award. Yes.
Phillip, even as you look at recovering that money, I was looking at the flow chart of some of those funds. Is there any implications to the law firms that were beneficiaries? Because they're saying, we are representing clients, but when you trace back this money, it is what we are talking about. Is there any implications to all of those law firms and all of those other beneficiaries that have been indicated there as having received, withdrawn, whatever benefited from these monies?
Oh, thanks. That's actually a very good observation, because you see, on the face of it, these monies are described as legal fees. Okay, but they're also huge amounts. The lawyer will probably justify it, because what normally happens when lawyers are paid, they have a minimum. There's a scale that says this is a minimum for my fees. But it's important for this information to also be out there. Because you will understand why some people will be making a lot of noise when EACC starts gaining even a little bit of success. And it is because of things like these. There are people who are not happy that their names are seen there. And they will be trying to justify that they are rendering services to their clients. But I recently saw one of the law firms which is listed there, and the senior partner in that law firm rubbishing government lawyers. There was actually a tweet, I don't know if any of you saw it. Yeah, there was a snide remark about how EACC, DPP lawyers are so good they've never lost a case before a certain judge. And I think that is rude, because we're all lawyers. But I can understand the genesis for that attitude is things like this. Yes, because they know on which side of this battle they are. And I'm just inviting Kenyans to just keep looking, paying attention. I think today there's someone else who was high-ranking member of the Law Society of Kenya, has also commented.
Yeah, we've seen that.
And maybe the questions we should be asking ourselves, firstly, as lawyers, I don't know if these people are speaking on behalf of the rest of us as members of the Law Society of Kenya, and on which side of this fight are they? Because nobody is stopping them from representing clients, but you need to just look at the picture and understand it for yourself.
Right. So, Phillip, from part of what I get from you, so apart from all of these comments that these learned fellows are talking about, if you look at what you as lawyers are supposed to charge, a minimum and a maximum, if you find, for example, that they charge 10 times more than they were supposed to charge, does it mean then that you would go for the difference, or you'll go for the whole amount? What exactly is likely to happen? What are the likely scenarios here?
Strictly speaking, we can only go after the people against whom the judgment was entered. Okay? We don't know if there was anything that was improper between these suspects and their advocates. But it is not a secret that law firms across the world, not just in Kenya, are often used as conduits for illegally acquired assets. That happens all the time. It happens everywhere. It happens in the developed countries. It happens here in Africa. It happens everywhere. Now, what we have done is simply to demonstrate that when this money comes in, all sorts of people are interested in it. Now, we may not take any action against the lawyers unless in future there is evidence that something has gone wrong. But strictly speaking, for now, the judgment is against the people who are accused in court, and that's Waluke, Wakungu, and the company Erad. Yes.
Phillip, what's the general sentiment? I mean, you already talked about, sleeping rather late last night and listening to all of this. What's the general sentiment at the EACC about this case? That's the first part. And then looking to other cases that would have taken on a similar nature around this same time when the first, sightings of this occurred, 2003, 2004, and then when the cases actually went to arbitration after, and then, into the legal process. For those who may have engaged in such acts, the feeling from out here is that, the acts may sooner rather than later fall on them. And you've often talked about cases like this then being used as deterrence to others. Do you see that this would be an example that would be used to either get people who may have engaged in such to maybe think about the fact that their fate may be coming sooner than later?
Yeah, thanks for that. Now, internally, the sense is one of deep gratification because of the amount of man-hours that have been applied to secure this result. And it's true. It's probably a warning to all other people who are engaging in corruption. And it contributes to one of the questions which, even the last time I was here, one of the questions that we keep being asked is, are we ever going to get any big fish? And I think this is an example, because we have a sitting MP there. We have a lady who is also a politically exposed person because of her relations and her connections. And we have a company which I think was being run by Jacob Juma, again, who was no small fry either. So I think it is a demonstration that we are taking a step in the right direction. And true, when you have a fine of this nature, it ought to serve as a deterrent. And I recall yesterday when the prosecutors were arguing about the sentence, and they were talking about how it should be proportional and so on and so forth. This is one of the reasons why we have penal consequences of this nature. It is so that somebody else who is out there thinking about pulling off a scam can think twice. You remember I mentioned during our last discussion when they do an evaluation between the risk and the reward. Now, in this case, the reward was huge, 577 million, but the risk was also huge. So I think going forward, people will think, can I afford to be fined 700 billion shillings and risk going to jail for 7 years? And I think most rational people will not do that.
And yet, my only cut in that whole 577 million shillings is only 40
or 50
or 50 million.
Yes.
Yet I'll be asked by the courts to pay 700 million shillings.
Yeah, and this is really the complex nature of corruption. You know, you see there's some withdrawals which were being made. I think 112 million.
Yep.
And
To some faceless. When you say that the recipient is unknown, what does that mean? How?
It simply means it's unknown. You know, like for example, if you withdrew money, say in cash, we will never know where it ends up. Yes, we will never know where the money ends up. So, and you know, you can only guess, because if you think about it, the National Cereals and Produce Board really tried to resist the loss of its money and other assets, but was not making any headway. You know, so you don't know who else was interested in this money.
In frustrating the whole process.
Absolutely.
Like you mentioned, Philip, that this was, you know, something that had huge impact on food security. This is, and many times when we see these kind of cases, we always hear that this could be just the one that was caught. Is it possible that there are many others that have been perpetrated through NCPB that you haven't been able to catch up with?
Not possible, but probable. This is the nature of corruption in Kenya. There are many cases, but we are working on them. I mean, a couple of years ago, there was a huge case involving NCPB again, and this was the maize issue once again. And we had a funny situation where people were delivering maize and being paid a lot of money for it, and it's a very complicated arrangement. So it's not the only one. And I doubt it will be the only one. The only thing we are hoping is that going forward, people will think twice about engaging in corruption, especially in such a sensitive pillar. You know, think about it. You know, this is basically the lives of Kenyans. You know, people might be dying of hunger, and somebody is busy making 577 million for delivering air.
Yep.
Philip, let me just take you back. Erad is a company. What happens to this company now? And knowing that one of the directors is long gone, so what happens?
So our understanding of the judgment is that they have their own fines to pay. Okay? And those fines, if are not paid by the company, because the company is a separate legal entity, it's a juristic person, I think there's another that if the company itself is not able to pay, that the directors who are surviving Jacob Juma will pay that fine themselves. Now, I don't know what that tells for the sake of the company. I don't know if the company is engaged in other businesses, it has other resources. But, you know, it is now clear the kind of business that Erad Supplies was engaged in. So I cannot say in future whether they'll be able to continue transacting with this cloud hanging over their head.
Yeah, well, nobody will want to touch them. I mean, if you're if you're a public officer, you see this as a procurement manager. Hey, you want to take off as soon as possible, you know?
Yeah, and you know, this is something that perhaps going forward should also be the norm. You know, the blacklisting of corporations which are engaged in corruption. So that is what is happening in developed countries. They just blacklist them outright.
Philip, you know what this does, right? With this historic win, landmark, I mean, so many adjectives are being used to describe this, is that people are going to want the next one. People are going to start asking questions. Okay, right? There must be more in line. When is the next one going to come about? Are there,
and especially bigger fish
than this? And
heads must roll.
We also saw another ruling whereby the court has said it shouldn't take more than 2 years for some of these corruption cases, right? So people are rubbing hands together and already saying, okay, who's up next to bat?
Yeah, that's to be expected. It's normal. It's human nature that now that they've seen we've done one, they are going to ask when is the next one. And on behalf of my boss, the CEO, Major Twalib, investigations are running. There are quite a number of them. Some of them are in court. You're aware of them. and then in the public domain. So there's two ways of looking at this. One, there's ongoing investigations, which we cannot discuss, but there's also matters in court which are in the public domain. So I'll just ask Kenyans to keep their eyes open, keep looking at our media, our website, our Twitter handle, and stay aware. I know, and we're enjoying the public, and this is what the CEO was saying the other day, that if you see something wrong, do not keep quiet.
Yeah.
Please come to us. We rely heavily on the public giving us reports.
And it's good you've mentioned that. Is there a proposal or a law as it is that
bill in Parliament?
Yes, that if somebody does not report cases of corruption or does not bring them out, then they are fined up to 5 million shillings. Shouldn't it be the other way around, that if I report and there is clear evidence,
you're awarded.
I'm awarded? I mean, if it's punitive, chances are I'll not cooperate. But if you're going to reward me for helping you bring you concrete evidence to nab some characters, then that may be more useful and productive as opposed to fining me for not saying anything.
I agree with you entirely, but the two are not mutually exclusive. Eh? On the one hand, it's somebody who is seeing corruption and not talking. I think that person should be punished a little bit. Okay? But on the other hand, we should incentivize the reporting of corruption. And I think was it last year or the beginning of this year when the president spoke about rewarding whistleblowers? Yeah, and I think there was a percentage which was mentioned for every report, but the report has to be a credible one, and it has to lead to either a prosecution or a recovery. And this is actually an international best practice. In many other jurisdictions, they do this with varying degrees of success, but the two are not mutually exclusive, and I agree. On the one hand, punish somebody who doesn't talk when they see corruption, and on the other hand, reward somebody who actually gives you credible information that leads to the prevention or punishment of corruption.
But maybe the place to start is by doing something for the whistleblowers that have previously been, they have suffered for having come out. Maybe that would be a show of, goodwill, that when you revisit those historical injustices, then there would be some hope for somebody else to know that there is actually an incentive to report. But as long as we have cases or stories of whistleblowers that have actually suffered punitive damages because of coming out, or they've been transferred from one office to the other because they raised an issue, then we will be looking at you with all manner of doubts.
Yeah, I agree with you, and I'm sure at the back of your mind you're thinking about the tragic case of David Munyakei and things like that.
Definitely.
It is unfortunate that perhaps at the time, I think that was it Goldenberg? Yeah. At the time that was happening, there maybe wasn't a framework for whistleblower protection. And as an extension of that, of witness protection, because, not all whistleblowers end up becoming witnesses.
Yeah.
But now there is a framework. And if you look at, this framework starts all the way from international instruments. If you start at the United Nations Convention Against Corruption, you have regional instruments, and even within our domestic law. So I am aware that in the Anti-Corruption Economic Crimes Act, there is protection for whistleblowers. If you go into the Bribery Act, there's protection for whistleblowers now, and we now have a witness protection agency. So in the event this whistleblower eventually transits into becoming a witness, there is a framework for their protection. But I am in full agreement that maybe as a gesture, the government could consider, some sort of appreciation for the people who have been victimized. And by the way, I agree with you, even the transferring, it is outlawed. You're not supposed to do anything that would be considered punitive to somebody who is a whistleblower. So I'm in full agreement with you on that.
Yeah, there should be some form of reparations for these persons, even if it goes back
the public
decades.
Ones at least.
Yeah.
Phillip Kagucia, Assistant Director, Ethics and Anti-Corruption Commission. Thank you very much for speaking to us this morning.
Thank you very much, Latif. I just had one last message.
Yep.
And as I said, ideally my CEO ought to have been here So he sent his apology, Major Phillip, who is a real major. And the reason I am saying that is because we have a suspect whose status from the military is not clear, because I listened to the mitigation and I thought, commit a crime and then everybody will discover that either you're unwell or you're a hero.
Yep.
So in the case of this guy, they kept saying how he was a major in the military. I'm not sure that was actually factual. And what perhaps we would invite people is to interrogate that statement, because my understanding is that the gentleman was a serviceman and perhaps never went beyond the rank of private. But
never a commissioned officer.
No, according to my information, no. So perhaps we can ask people to verify that for themselves, because it tells you something about the nature of the person.
The character, yes.
You know, aside.
Yes, Phillip.
Sorry about that. Yeah. So aside from defrauding Kenyans of these huge amounts of money, it is quite possible that the gentleman has also been masquerading as a commissioned officer.
Right.
Wow.
Hey. Wow. That's a hot one.
Yeah.
Thank you very much, Phillip, for speaking to us.
Thanks for having me.
Have a good day.